Indeed, thank you for inviting me to talk to you this morning. I view the world obviously as a regulator, which is a somewhat different perspective to yours. I certainly was fascinated by some of the earlier presentations. Some of them I will be commenting on indirectly in my own presentation. I just wanted to pick up on two of them which are of very direct interest to me at present. First of all is social media. As Paul mentioned in his introduction, we have the interesting task of overseeing the data protection activities of some of the major social media companies. We'll be publishing tomorrow a review of an audit we carried out of Facebook's Irish operation, which is responsible for users throughout the European Union. We relied on the valuable help of the UCD Cybercrime Centre in carrying out the technical analysis associated with that audit, but certainly when I was listening to some of the risks linked, for example, to apps, which are a significant feature of the Facebook platform, I'm sure some of you will be interested in what our technical expert made of those. I was also interested in the link more generally to law enforcement. One of the hats I wear is I chair Interpol's data protection oversight body, so I've become quite familiar with that organisation's work, for example, in trying to combat the various forms of cybercrime. I think, as Paul said in his introduction, in fact, it is now obviously a key element in combating so many types of crime, whether you're talking about terrorist financing, child pornography, money laundering, etc. Anyway, coming back to what I'm actually going to talk about, which is on the slide there, I'm going to look through, first of all, some of the risk factors associated with data processing. Again, this is very much home territory to you, but I will view them from the perspective of a regulator. Then talk about the laws that apply in data protection. I think, as Paul mentioned, there are obviously other laws applying as well, such as the Cybercrime Convention. I don't think Ireland has quite got around to ratifying it yet, but hopefully will. And there are also other laws involved. And finally, comment on future law that's coming down the track at us from Brussels, with some pretty scary fines contained in them. So, again, you know this stuff. What are the risks for any organisation in terms of if it doesn't handle data properly, and that's obviously your bread and butter. Obviously, there's the loss of customer and client trust, and I'm sure many of you or the organisations you work for have learned that the hard way. Also, increasingly, data protection authorities are becoming firmer in this space. In Ireland's case, we have very strong enforcement powers, and we don't hesitate to use them when companies fall down in their responsibilities to their customers and clients. I quoted there a figure which is from the States of the estimate of the cost of actually remedying a data breach. It's quite significant, and obviously from your point of view as professionals, you're trying to persuade organisations not to go there. In other words, to take the type of protective action that will avoid that type of situation. At present, the fines in this area are quite small in Ireland, but they can mount up. For example, for unsolicited marketing using electronic means, you can be fined €5,000 per message. Now, usually the judges here are fairly lenient, so they don't throw the lot. But suppose you wrongly send an email, a marketing email, to say 1,000 or 50,000 customers, well, potentially you're facing a very large fine, in fact. And as I'll comment later, there are far more serious fines coming down the track at us due to new European law in this area. Reputational risk is obviously the most serious penalty that any organisation can face when it fails to get its data security right. And I've just given you there some of the headlines that have appeared in the recent year or two in Ireland for Irish organisations. Again, this will be very familiar territory to you. Certainly in our experience, the risk factors associated with handling data are, first of all, people. It's the ignorance, people who don't know what procedures to apply, people being careless, and then, of course, there's the area you're dealing with, cybercrime, which is malicious involvement with data. Again, our last speaker referred, and so did Paul, to the particular challenges posed by mobile devices and smartphones. As he correctly pointed out, every smartphone we carry these days is, in fact, the same as a laptop, and if you lose it, it has the same type of consequences in many cases. Also, I think an important theme of your conference this morning is the challenge posed by outsourcing to a cloud. I'm glad that the comment was made that, in fact, you cannot outsource your responsibility to a cloud provider. But I think also it was very important that the point was made that, in fact, your security can be enhanced if you choose your cloud provider very carefully and make sure that they have the type of they can offer the type of guarantees, in fact, that many of the major cloud providers now do as a matter of competitive advantage. So there was already mention of things like being able to demonstrate certification to international standards, then standard things you need to check like access controls, data recoverability. What happens if there is a data breach? To what degree does the cloud provider offer your organization the right to audit its systems? And also you have to, if you're an organisation based in Ireland or the European Union, you have to have regard to where the data is located because of the restrictions that apply on the transfer of data outside of the European Union. I think an increasingly challenging area, and particularly for smaller companies, is the degree of control that you actually have over the outsourcing when you do outsource to a cloud provider. Because the important thing to remember is that you as an organisation remain responsible for the data. I as an individual or a customer gave you the data, I expected you to mind it. You have the freedom under data protection law to outsource it to a cloud provider, but you are responsible for the decision. But increasingly there is an asymmetry in power between the big cloud provider in particular and the small company. So you're told, that's the offer. Sign there, please. So it is an issue there, and that's why in particular I think for smaller companies the ability to be able to rely on third-party verification of, for example, that there's a sign-up to international standards is going to be so important. But I'm also glad we hear reference to the red herring that is the Patriot Act. Frankly, when you're outsourcing to a cloud provider, the least of your problems are the Patriot Act, and I'm very glad that that red herring has been knocked firmly on the head. Data security breaches, despite all the technology there, are increasing. Even though we only at present have a voluntary system of data breach notification in Ireland, we've seen a huge increase in the number of breaches coming to us. And it's interesting, in fact, that it's the more traditional type of breaches are the main ones. It's things like sticking the wrong piece of paper in the envelope is actually the main form of breach that we face, not the dramatic stuff about hackers and so on. So it does come back to very basic mistakes, including basic errors on the part of individuals rather than the more dramatic stuff that you do face and obviously that you should be concerned about, in other words, the hacks that take place on major organisations. And obviously those of you who will be providing services to major organisations, they obviously have to be highly concerned with external attacks on their systems. But it's interesting, in fact, what the actual experience is of data breach reports to us. Turning now to the, I'm sure for you, the boring stuff in many ways, what the law is in this area in data protection law. And I will only comment on the data protection law, not the other laws that surround it, like criminal liability. There is a specific piece of legislation in Ireland dealing with misuse of computer equipment. And then when Ireland ratifies it, there is the Cybercrime Convention. As you probably know, our data protection legislation is based on European law. There's a general law dating from '95, which is being updated, and then the specific law governing electronic data. From the perspective of this audience, the key data protection rule you're concerned about is the requirement by law to keep personal data safe and secure. Now, the law doesn't actually give a huge amount of guidance. It talks about adopting appropriate security measures to prevent unauthorized access to, alteration, disclosure, destruction of data, provide a level of security appropriate to the harm that might result, and have regard to the state of technological development and also the cost. But they do give an indication of the type of things that an organisation needs to consider when it's deciding for itself, in fact, what is the appropriate level of security we should have, or when you as professionals are trying to persuade a board, how much to spend on it. And obviously, it unfortunately can help if the organisation has just suffered a data breach, because then suddenly I'm sure you find an open purse facing you, as opposed to the usual difficulty in getting budgets for data security. In the telecommunications area, the situation has become more challenging for companies in this area. The security obligations have been strengthened. They're obliged as a matter of law to report any data breach, first of all to their customers, but also to the regulator, which is us. There are also new restrictions on them in terms of location data. There are stricter rules on the use of cookies by users of telecommunications data. That's bringing it outside telecommunications companies. And again, for those of you who are interested, there's extensive guidance on our website. So in terms of any organisation holding personal data or anybody advising them, I mean, it's actually the first thing to do is to find out what data are you actually holding and how are you holding it. And data protection law challenges you on every aspect of that. In other words, why do you collect it in the first place? Do you need it? What it's used for? How long are you holding on to it? Who has access to it? And that means not just access from outside hackers, it's also internal access, because increasingly the complaints we deal with cases where in fact the problem is internal to an organisation. Someone has accessed someone else's personal information for reasons unrelated to the business. Obviously, in the worst cases, there are people who then have stolen the data from the business, and we've had to deal with one such case recently, which was reported in the media. We have general guidance on data security. Again, it reflects what our law says. So it talks about simple things like, do you have good physical security? What are the good IT organisational measures you have? What do you have? Do you have good access controls, internal, external? Do you have audit trails? Could you show that there hasn't been a data breach? Or if there was one, who in the organisation is responsible? With good audit trails, you can. If you don't have audit trails, you can't. And it said we go through each of these in our guidance with a view to organisations applying them directly to the particular circumstances that apply in their own organisations. We also give advice on what to happen if things go wrong, and we do accept that organisations, with even the best security, things will go wrong. It's very hard to deal with every aspect of the human factor in particular. So as long as when we go out into audit an organisation, we look to see an organisation that's serious about security, serious about data protection in general. And you can see very quickly, is this just a piece of paper the legal department drew up, or does it actually mean something to the operator down there who's dealing with customers? And obviously, if we find the former situation, we come down very heavily on that organisation. If, as we hope, we find a situation where data protection is dealt with seriously, then we're far more understanding if there actually is a data breach. I think from any of you advising an organisation, or if you're within an organisation, the key point is to get the organisation to carry out a risk assessment based on the types of data that it handles and the risks associated with it. It's very important that a board understands the risks and signs off on the policy that does apply. After that, the policy should reflect a transparent and balanced approach to collecting and using personal data. That includes things like making sure people are aware of their responsibilities, that the technology is good. You have good technology which, for example, has good access controls that will clearly indicate who has access to a piece of personal data, and obviously, crucially, that particularly for portable devices, there are good policies in place to protect, if you like, the organisation. As mentioned in the last presentation, the bring your own device challenge is very much there now for organisations, and it's becoming a major challenge for people responsible for IT security in an organisation. Obviously, compliance with international standards is something we look for when we do carry out an audit, and it's very important that there be a clearly assigned data protection function. As I'll explain, this will become a legal obligation in the future in the law that's coming down the track at us. Just to help you also, we do have a manual on our website which basically takes you through the type of things that we look for in audits. And it's the same thing whether we're auditing, if you like, the corner shop or Facebook, which we were doing or reviewing yesterday. Again, we go through the type of things that we want you to do. That includes for you IT system security. Obviously, we do look to see that there are people in charge who know what they're doing, that they have proper security in place, and that it's carried through the various types of ways and the various technologies in use in the organization. Coming now to the future, and it was mentioned by Paul in his introduction, that arising in fact from when Ireland voted twice for the Lisbon Treaty, when we voted the second time and put it into force, data protection is now a treaty obligation at EU level, and it's a fundamental right that we all enjoy. Arising from that, the European Commission published new draft laws in January last. A crucial point is that the law in future will apply uniformly and directly in every member state. At present, it's a directive which is translated into 27 different versions of law. In the future, there'll be one single law applying across the European Union. The drafts are currently being negotiated. You can expect the law to be in place in around 2014 and probably to be actually implemented in 2015, 2016. And to give you some of the things that are the principles that are reflected in that new law, first of all, it does now emphasize that data protection is a fundamental right that we all enjoy. And therefore, if you like, it's up the ante in terms of the balance that is to be struck within an organization, let's say, as opposed to personal data versus other things you have to consider about, obviously, commercial viability, data security, and so on. Obviously, because it's a European Union measure, there's also focus on the free movement of personal data. In other words, that the law should be sufficiently robust that all EU member states can and are willing to rely on data being able to move within the European Union on the assumption that the law is strong in every member state and is being properly overseen. Interestingly, and particularly in a world where data flows seamlessly across borders, in future the law will apply unambiguously to any company providing services to customers in the European Union. So that means, in fact, that having your data center, having your services located outside the European Union won't matter. You'll still be subject to European Union law, and for most companies will have to appoint a representative within the European Union against whom fines, for example, can be imposed. Again, some principles are going to be imposed which are going to be challenging for anybody within an organization. A first one being data minimization. In other words, it now becomes a very specific requirement that you must minimize the amount of personal data that you hold. Organizations are going to have to be far clearer as to what data they're collecting and what they're doing with it. The right to access your own data is going to be strengthened. I know it's something that many of you will have to deal with. Many of you will regard it as a major nuisance. At now, you at least can charge people the princely sum of €6.35 for the service. You won't be able to charge even that in future. So basically, get used to the idea that once you have personal data, anyone at any moment has the right to demand a copy of all of it, and you must pony up within a relatively short time. There's a strong emphasis in the new law on organizations being responsible, being accountable for the information that they hold, in fact. So basically, both their customers and regulators will say, you have the data, it's up to you to show to your customers by the way you guard that data, by the security measures you have, that you can be trusted with it. In future, there's going to be a requirement for any organization, any public body and any private body with a significant number of employees or processing particular types of data to have a dedicated data protection officer who will have to act independently within the company to basically make sure the company is complying with its data protection responsibilities. There's going to be an obligation on organizations from now on in to adopt a privacy by design approach. In other words, as you develop new services, new products, you're going to have to carry out a privacy impact assessment as to what's the impact of this going to be on the privacy of customers or clients. There will be encouragement of of kite marks or seal systems, which basically would allow an organization to demonstrate to, for example, a seal organization, as organizations like Trustee, for example, in the US, who will certify that, for example, your website meets certain standards. An interesting challenge for IT professionals is going to be the obligation to make data portable from one platform to another. So I know there's a lot of scratching of heads going on within the IT departments of major entities, particularly cloud providers, as to how to give effect to that, including, of course, the commercial aspects of that, including, for example, when data is stored using proprietary software. The right to be forgotten really gets people to pull their hair out in IT systems, but it's basically, as it's drafted at present, it's basically, first of all, a requirement to have a retention policy around data, which already exists, and to specify what it is, and then a requirement to delete personal data if on request, unless there's a good reason to hold on to it. There's also going to be a requirement on every organization to have the type of data breach notification regime that currently applies in telecommunications companies, and that essentially not only involves strength and security. If you do make a mess of things, it involves an obligation to tell customers you've had a breach, and also to tell regulators you've had a breach, and obviously face the music in terms of fines if they chose to impose them. And this is, I think, what Paul mentioned at the beginning. In future, there's going to be an obligation that every member state gives its data protection authority the power to directly impose sanctions. And the sanctions can be up to €1 million or 2% of your annual turnover, depending on the nature of the breach. So I'm sure that's good and bad news to you. For some of you who are desperately trying to get money for data security, I think that should get CEOs to wake up a little, as at present, obviously, if a hard-headed CEO asks, well, what's going to happen to me if something goes wrong, and you quote the sort of fines that are there at present, well, I can understand the reaction. I think with that sort of fine level being imposed on you, I think that should cause people to wake up. There's also going to be, on top of that, a right of individuals to seek compensation for damage they suffered, including a right to take the sort of class actions that companies at present face in the United States. So thank you very much for listening to me. There's further guidance on our website, and I wish you the very best for the rest of the conference. Thank you.
Are you happy to take one or
Yes.
two questions?
Yes.
Anybody got any questions they'd like to ask Mr. Hawks? Because I know you can't stay